here. I have Ethan, our committee attorney, and I want to thank Pat for getting this set up. Today's hearing is on a number of different topics. In short, youth court reform / information. I think we have Senator Thompson, Senator Turner Ford, Senator Boyd. I think that's Senator Hobson. So I'm going to tell the members, what's important is be sure to get the packet of documents that Ms. Pat's prepared. I think it's really important. We can't cover it all in this meeting, but the speakers that we have lined up will supplement that. So please be sure to get those if you're not here in person, and she'll have those for you. We will, in terms of like questions, happy to take questions as we go. But we will be out of here at 12, if not before. So I will be doing the timing and all of that. So we will be out, and we don't have to take the whole 2 hours. But I want us to hear about this, and in a minute, I'm going to turn it over to Vicki Lowry from Administrative Office of Courts. As many of you know, she was put in the position by Chief Justice Randolph to focus on our youth courts with the things that we've been working on. So we're going to hear from her. And Ms. Pat, did that extra file, the extra copy you handed, that's in everybody's packet? Okay. So we will hear of the recommendations from AOC. And let me say that what you're going to hear is data driven. It is analysis driven. This isn't like Bryce Wiggins and somebody else sitting in an office trying to come up with something. This is what has been looked at in different ways. And so I appreciate the work that's gone into that. And then we will really just get into that. I do want to take it a little bit out of order on the agenda. And I'll just a brief background for doing that. One of the items is the My Kids technology audit. If you recall, 2 years ago, that was Chairman Hood's bill, which we supported, obviously. That audit has come back. I feel that it's was done very well in terms of what we got out of the RFP. We're going to hear about that. I want to do that one first, which I've told Vicki about that. So with that, no further ado, as they say, and I will turn it over to Vicki. And Vicki, if you'll just highlight, I guess, what the recommendations without getting into the specifics, or how y'all came up with that and on what they're based, and then we'll go into the My Kids, because I want to get to that and the members to hear about that. Is that on? Is that on? Yeah, speaking to the.
It's on. Can you hear me better?
Yes, there we go.
Yes, thank you. Thank you, Chairman Wiggins and senators. We greatly appreciate you giving us this opportunity to share with you recommendations for improvements to youth court. Consistent with statutory authority, the Administrative Office of Courts has retained consultants to assist the state in developing what is essentially a 5-year strategic plan for making systemic improvements to youth court, child welfare, and juvenile justice in the state. We have some of those consultants with us here today in person, and the remaining with us virtually. Working individually and collectively, the consultants have made 12 expert recommendations for improvements to Mississippi Youth Court. And there's a one-pager that everybody has, it's yellow, that lists those 12 improvements. They include a full-time, dedicated, trained youth court, full-time judges, full-time court staff. They also include uniform intake and predisposition protocols, high-quality, independent legal representation, agency-directed pre-petition assessment, adopting the agency representation model for child welfare, developing statewide diversion for juvenile justice, youth court being the only court option to address truancy in the state, expanded and dedicated prevention programs and services, a uniform crossover youth court protocol for children that are involved in both abuse and neglect, as well as delinquency proceedings, modern technology, which refers to the My Kids audit that Chairman Wiggins mentioned earlier, addressing access to justice at Mississippi Youth Court, and strategically maximizing federal funding that is available for us to make these improvements. So first, we'll address the My Kids audit.
Yeah, please, let's do that.
Okay, so with the My Kids audit,
Let me say to the members, you have in your packet, and Vicky, please correct me if I'm misstate, but you have a copy of the PowerPoint of the results of the My Kids audit, and what it says. And then you also have in your packet, and I will say this, the letter that was sent to us from Catherine at the AOC about their recommendation on the audit and their take on the audit, which is it should happen. That's how I say it. So
that is our ask, Chairman. And then for those of you in person, you have a one-pager that highlights the key findings and recommendations from the My Kids audit, and it's this blue piece of paper. And so the My Kids audit, as Chairman Wiggins mentioned, was a legislative mandate, which we welcomed. We did do an RFP and hired Vertus Solutions to conduct that audit. And Clay Esterling is with us virtually, I believe.
while we're
Hey, Vicky,
getting
yes,
them
I'm here.
up, I will state, I found the letter from AOC, that in part why it's really good is because what they're recommending is based on the Microsoft infrastructure that the state already uses, which has allowed the cost, I guess, to be easily or lower,
Yes.
and work on top of that. And then I'm paraphrasing, allows what I call all the stakeholders to be able to talk to each other. That includes CPS, DHS, youth court, and more. And the fact of the matter is the My Kids system is antiquated and at least 30 years old, which in terms of new technology, let's just call that the old technology. So,
It's old technology. We have likened it to a flip phone.
okay. So thank you for saying that. So basically we're using a flip phone to service the children in youth court. Now, okay.
Yes.
So with that, I'm going to, if we can get Clay up there.
Clay, would you like to take it from here?
Sure thing. Can everyone hear me okay?
Is he there?
Oh,
Clay, we cannot hear you.
how about now? Can you hear me now?
He's not on? Okay, Clay,
See him.
Clay, you may either be muted and we just see your name, so that's fine.
I'm trying to speak. Can you guys hear me?
While Clay addresses technology, and gratefully he is a technology expert, I'll start and just mention that this audit took place over a 12-week period, and They really assess what My Kids does in terms of serving 2,000 end users. And they visited a half dozen courts and also interviewed judges, court staff, social workers, CASA volunteers to ask what works well and what does not work well with My Kids. They also collected 269 pieces of documentation, conducted 56 interviews with 14 different types of end user groups. And I'm sorry, I misspoke. I said they visited 6 courts. They visited 12 in 8 counties. So the assessment was really very thorough. And Clay, do we have you now?
Can you hear me now?
Yes, fantastic. I was just teeing that up for you.
Awesome. No, you did a
Okay.
great job. Thank you very much. Yeah, so without, avoiding the repeat of that information, to Vicky's point, it was a very thorough audit across 12 weeks and with lots of virtual conversations as well as in-person conversations.
Clay,
And I,
this is
and
Clay, this is Chairman Wing. If you would, please, for the benefit of the committee and the audience, give just your brief background
absolutely.
uh, and brief background, and then we can jump right into it.
Perfect. Yeah. Fair point. Yeah. So my name is Clay Esterling, and I was obviously leading the technology audit for My Kids. My background, I have over 15 years of technology consulting experience. I graduated from Auburn with electrical engineering degree, and then over those last 15 years, I've been very focused on two main areas: telecommunications and public sector. I've I started off focusing on implementation of applications such as Microsoft Dynamics or other tools, and then in the the later half of my career has been more focused on this type of technology assessment and review. So that and I I currently live in Georgia, so that's a very quick intro for me. But yeah, that's kind of where I'm coming from.
Great, thank you. Okay, jump right in.
Perfect. So, as Vicky has mentioned, there were 12 specific findings. We won't go over every single one of those here today. I want to touch on a few critical ones. So, and as you have already hinted at, one of the things that was a major concern during the audit that is that My Kids today doesn't interact with any other system. So it's isolated. And because of that, you have data. There's a lot of issues with that, but I mean, the primary symptom that you see is a data drift, right? Like where data in one system for maybe child protective services doesn't match the data to the youth court or DYS or et cetera. You can extrapolate that out to any system. Systems that are not talking to each other are going to have data drift. So you might be in sync initially, but because you're not staying integrated, those drift apart. That's kind of point one there. Point two, another one of our major concerns is there was a lack of notifications and a consistency of those notifications to different user groups based on when court orders were entered into the system. So for many of the groups we spoke to, it was common that they had to manually remind themselves to go check in on the system. Hey, let me log into My Kids to see if there's anything I need to do or something has changed. Or in a few unfortunate situations that we captured or heard about, it was just where the alert was missed. So because you didn't check in on that day, something changed for a case that you were working on and you didn't have awareness of that. So that's another large one of the findings/concerns. A third point there, the inability to read text or absorb court orders digitally, right? So yes, files can be uploaded and attached, but is the system able to process and read those and categorize and tag them in an appropriate way so that you can run searches, build reports, and those type of things? And that's today that is not possible in the current My Kids system, and that was definitely a point of concern. And then lastly, on this slide is just calling out the lack of consistent access. So because access, was particularly gated in certain roles, as we moved between county to county, we saw wildly different levels of access, even within the same role. So a public defender in I'm just picking a county in Hinds County may not match what was in Choctaw County as an example. And obviously, and we found many examples of that where um, the both the granularity of the access as well as how broadly the access was given were very inconsistent. And a lot of that comes back to the technology problem in the sense that the tool itself is set up to allow such variability of access that you can find yourself in the situation where you have multiple public defenders with very different levels of access, and what they see in the tool, it can be wildly different. Any questions on this slide, or Vicky, anything else
Well,
to add to this list?
Clay, let me do this. So I don't know if you have in front of you the audit summary presentation and the key findings that y'all had. I'm just reading them out in the
Yeah.
interest of time, and you comment on them. But key finding number one: my kids consistently contributes to youth court delays and process inefficiencies due to a lack of external notification. Key finding number two: my kids does not offer a clear and comprehensive way to track youth statewide across multiple cases. Number three: my kids' access is not consistent across youth court user groups, particularly defense, effectively hindering defense's ability to perform duties. Number four: access and permissions are difficult to manage and overly complicated. Number five: my kids lacks advanced search and configurable reporting capabilities, limiting user ability to quickly find youth, relevant current or prior case information and documents. Number six: large majority of users describe poor tool performance with consistent freezing, crashing, and work loss, leading to duplicated efforts and delays in processing. Number seven: majority of users indicated my kid's tool is not user-friendly, lacking intuitive process flows with clear signaling. Number eight: majority of users indicated training was neither timely nor informative, with most users relying on self-teaching or being taught by another member of the court. And number 10, it relies on outdated technology. So Clay, does all that sound fair? And can you weigh in on those findings?
Yes, absolutely. I mean, yeah, those are the core pieces of it. And what you're looking at now, what's on screen, is related to finding number 7, the unintuitiveness of the tool. So throughout our multiple interviews and I think around 82 hours of individual conversation and many different groups, we collected all the feedback, and this is in addition to our own experience of navigating the tool and using it. We categorized issues into one of these buckets. So a lot of this came back to the overall challenge of what it feels like to use the tool, the user experience. And so what you're seeing here is a summation of all that. Between each of these rows is a more detailed reasoning that led up to that particular score. But this is what we're calling a report card for the overall user experience. That the tool itself has a lot of usability and clarity challenges. The navigation and consistency of how to move between screens is poor at times. The cognitive load and accessibility of the tool, meaning if you're brand new to the tool, there's a huge learning curve and a huge spike to figure out where to go, how to use it, consistently between different cases, and the amount of feedback that the tool is providing you also scored very poorly. And by that I mean something like a guided workflow. If you think of something like TurboTax, where it's giving you feedback on, hey, you're step 5 in the process, and I'm realizing that you did something wrong. Let me jump you back to the beginning of that. That's an example of a more guided workflow experience that's high levels of feedback. And so I just wanted to kind of articulate what's on the screen here. But to your point, our effort here was to try to trim down the findings. And I know you have the full list here, but I wasn't going to go walk through each one. I'm happy to talk through any one that you'd like me to hit on in more detail. But what's being displayed here is a focus on that unintuitive user experience.
And the overall grade is a what?
Overall grade was an F, based on the system, helping or hurting a user to do their job easily, right? It hinders user performance, it increases errors, requires excessive training. And it doesn't help with the workaround behavior.
Okay, so, and what's, now that we have that understanding, what is your recommendation as to, in terms of the audit and I guess the RFQ that went out?
Yeah, I'm turning on my camera here. Sorry, I should have had that on earlier. I'm not sure if you're able to see me now.
There you are. Now we can see
Hey,
you.
there's a face to the voice. Yeah, so to your question, my overall recommendation is that a replacement of my kids is needed, and um, where we actually built a very comprehensive list of multiple options and try to weigh pros and cons for various approaches to that. Do we rebuild my kids? Do we, can MEC be used? And there's actually a slide on that where I think MEC is a great filing database tool, but it has lots of additional work required to fill in for what my kids does, and primarily that's around the ability for statewide reporting, case management, and all of the pre-petition activity. So um, the net story there is that MEC is not an easy drag and drop replacement for my kids. So that's what led to the recommendation that building a tool in Microsoft Dynamics would be the best fit. And you touched on this a little bit earlier, but yeah, the benefit of that is that the infrastructure for Microsoft Dynamics is already provisioned. There's already a tenant for government agencies within Mississippi. So the identity systems are already integrated. Security policies are already enforced. So there's a lot of that legwork that's kind of already there and ready. So that's another reason why that's, in addition to the fact that it is modern technology that would allow you to integrate with other tools, it would allow you to build views and dashboards, and we'll get to that in a minute, where it's kind of an all-in-one, one-stop shop for everything I need to see about a child in custody and what that would look like, right? So where I'm going with this is that with Microsoft Dynamics, you have smarter notifications. You have the ability to integrate with systems out of the box, right? They'll have the ability to check it to touch with pathways and potentially other tools from an integration standpoint. The order generation and automation can be something that is enhanced and modified. And I think one of the findings that I talked about earlier is a lack of smart and intuitive notifications. So Microsoft Dynamics would build that in as well. Let me pause there and see if there's any other questions before we get to this last view. Okay, so what you're seeing here, oh, sorry.
Go ahead. No, go ahead.
What you're seeing here is a mock-up of it. It wouldn't look exactly like this, but this is an idea of what it could look like in Dynamics to have an all-in-one child-centric dashboard. And as you can imagine, it'd be very powerful to pull all of this information together. And it wouldn't just be from youth court tools. You could pull potentially from pathways or the CPS tool. You could pull from other areas to help populate this with behind the scenes integrations. So here is an example where you could have the child's name, their current phase in the process, their next court date, as well as what is the overall plan. Are we still focused on adoption, or is reunification the path forward? A little bit of a tracker down to say, like, are they, phase 1, 2, 3, 4? How long have they, how many days until their adjudication, time to permanency? Are we compliant with federal and state timelines? And then all that relevant history could be packaged up in a way that was really accessible. And so back to that report card, the F grade, where if you're a brand new user to the tool and you want to help this child, the existing tool makes it really hard to find all this information in a very intuitive and easy way. Whereas a more modern tool that's supported by integrations could build a dashboard like this and more that would allow you to, without much training or knowledge, to very quickly know, okay, I see what I need to do or how I can help because it's all presented in a much more intuitive and easy to learn way.
Okay. Yeah, I don't want to, we're not the technology committee, so, I think I have one question, and then I want to get from Vicky, you from AOC's perspective. Um, Clay, so as I mentioned earlier, would all the different agencies that come into contact with a child, let's say, that's in youth court, would they all have access based on the case? And I'm gonna do an analogy here. Under the current court system in the state of Mississippi, if you're in that case as an attorney or as a party, you have access to it. Does that happen here with what your recommendation is and what y'all provided?
So with a more modern tool what I would recommend is a better approach to access. It doesn't have to just be county by county or statewide access, right? It can be case by case, and it can be more nuanced without it being as complex as it is today. So there's a little bit of a paradox in the setup today. It is very, very granular access. So you can give access down to a very specific button or feature. However, what cases you have access to is statewide or everything in the county. So to address your question specifically, it would be, in my opinion, it would be an improved experience to have the ability to assign access to a specific case so that you don't have to worry about, okay, this person is representing someone in this particular county, seeing information about other cases that they're not relevant to.
Okay, great. Vicky, from the standpoint of AOC, what is y'all's thoughts on this?
We would very much like to upgrade from a flip phone. The 1999 court technology is not surprisingly outdated. There's a tremendous amount of effort that has to go into mining data from this system to be able to make data-driven decisions, as opposed to something more akin to what we're seeing on the screen now that would enable agencies, courts, and attorneys to meet statutory deadlines and other expectations. It would also allow for the court technology to interface in real time with the child welfare agency, with the intervention courts, with the Division of Youth Services, so that we could have real-time data exchanges of the information that should be shared. So I think it would enable courts in particular to make more informed decisions to benefit children and families if they could have that holistic picture. And I think that agency employees as well as court staff would be much more efficient if they had a more intuitive system that, like Clay said, operates more like TurboTax. If you get something wrong on step 5, TurboTax doesn't let you go to step 6. It makes you back up and fix it. And so one of the things that my kids struggles to do is to give us accurate data for us to report to the legislature, for us to share with end users, for all of us to decide what needs to be done to improve youth court. The numbers are very tricky. For example, Clay mentioned that this court technology can't read the content of an agreed order, which for lawyers, that makes us scratch our heads, right? I mean, the system recognizes there's an attachment there, but it can't read the text. And so just as a quick example, but there's some real challenges there. And for us to be able to get good data, this last session, the legislature adopted mandatory reporting requirements for youth courts. And since that time, the AOC has asked youth courts to provide that information to us monthly so we could try to reconcile what my kid says versus what the reality is for those youth courts. And we've discovered a lot of shortcomings in the system. If we try to determine in response to the legislature's request the number of children that have been adjudicated, abused, or neglected, the My Kids system can't run that report accurately. It doesn't know the difference between an adjudication that was held, one that was scheduled, or one that was continued. So we really want to get to a place that we have credible data so that we can make informed decisions and that we can always know legally and physically where a child is in these systems.
That was my next question, which is the things that we've been working on for the last couple of years. Would this aid us? I'm not saying it solves everything, but would it aid us in trying to move kids through the system to deal with the things that we've been dealing with?
Absolutely. We would have eyes on literally where a child is in the legal sense as well as the physical sense, and a single screen. And we could share real-time data with a child welfare agency, also with a Division of Youth Services. I mean, right now, we don't do that. Most of our data is siloed.
I wasn't going to say, but I'm glad you mentioned that, because I was invited to the Harrison County Blue Ribbon Commission, which all got started through the baby, forget the name, DJ, I think. And what was explained to me was that actually was part of the issue. And so it sounds like this could address something like that. But I'm not asking you to comment on it.
Thank you.
Just saying, they raised that issue on that. Okay. Well, so with that, are there any questions? I'm going to open it up to the committee online or Senator Bradford. If any questions for Clay on the issue here. Okay. I think that's a good overview. And with that, Clay, I think you're welcome to stay on. There may be some questions towards the end, but you're welcome to stay on. But we're going to move on to the next other topic on that. But thank you for your work on that.
Sounds good. Yeah, absolutely. Thank you.
Thanks. Okay, so I'm glad we got that. And Vicki, I'm going to turn it over to you for the recommendations that y'all have.
Fantastic. Thank you. We'll go to what is currently recommendation number 2, and then I'm going to step away and let the consultants take it from there. But our second recommendation, consensus recommendation from the consultants, is for the state of Mississippi to have uniform intake and predisposition protocols. And this is a conversation that we've been having for the last couple of years. And I wanted you to know that we are moving in that direction, thanks in large part by the state's investment and the PIN transfer from DYS to AOC that has allowed us to have an AOC intake officer in every chancery district in the state. You may recall that last year when the Youth Court Commission reported to the legislature, part of that report reflected that 38 counties were not paying anyone to handle intake. So we assume from that they had no staff to handle intake. So these AOC intake officers are going and prioritizing those 38 counties first and making sure that they have the support that they need to take care of children in Mississippi. And then we also have adopted a statewide uniform protocol and procedures for intake. We have trained the AOC intake officers on that protocol. And then next month, we will start training county intake officers so that we are all entering data similarly, accurately, and we're getting apples to apples comparisons on our numbers. For example, in some parts of the state, truancy is entered differently. It may be entered as incorrigible, or it may be entered as something else. So then when we're asked by the Department of Education or the legislature for an accurate number on the number of children who are truant, we don't have it.
Well, let me stop. I'm sorry. Let me stop you there, because Lieutenant Governor Hoseman has made that a huge part of the agenda for this session, and the Senate in particular, and I think the House is committed to addressing truancy. But from what you found, why are we not getting accurate data on truant? Because if we're working to get these kids and their parents into school, why are we getting inaccurate data, or it's not being reported consistently?
I think it's really 2 things, Chairman. I think it's that we're using flip phone technology that is not driving the intake process the way TurboTax would drive us if we're submitting our tax returns. The second thing is until now, we have not had a statewide uniform protocol for intake. And so we have had 82 versions of that to some extent, but we will very soon have a version of that so that the data that's being reported is something that accurately reflects the information that the legislature and the state need to make informed decisions. And then I wanted to mention too that you may recall that the Division of Youth Services acknowledged in the last year or so that they lack statutory authority to handle youth court intake and that their employees would no longer be doing that. So these AOC intake officers have been able to step in and fill that void. And they are also helping clean up the data because again, a lot of courts lack staff, but also the technology is not intuitive. And so there are mistakes in the system that skews the data. And we really want to get to a place that we have better data integrity. So as an example, these AOC intake officers in their first 90 days have administratively closed over 95,000 cases. I want to be clear that these are not cases where petitions were filed. These are cases where the Child Protection Services Agency recommended that no action be taken, and the court agreed that no action should be taken, but the technology didn't recognize that without someone having to go through multiple screens and mine down and click a super special button that nobody would know to click. And then frankly, we were not training anybody to click because we didn't understand and appreciate it either. So it was giving a false sense of the caseload that a court would have. And we certainly don't want it to appear that a court is not moving their cases. These aren't cases. So the AOC intake officers have been going in and doing these mass closures for those counties so we have a more accurate reflection of what the court's current caseload is. So they've been busy in the first 90 days, and we'll have more reports for you soon. And then at this time, I would like to introduce, we have two of our consultants are here with us in person, Jerry Milner and David Kelly. And they're with Family Services Group, and they are going to speak with you about some of the other recommendations. We'll yield the floor to the juvenile justice expert who's going to speak virtually after that. But I did want to share with you, I'll brag on them so they can be modest when they get to the microphone. But Jerry Milner ran the United States Children's Bureau. He led that during the first Trump administration and is very familiar with what these standards are, what the best practices are, what's happening in other states. And his partner, David Kelly, among other things, he led the National Court Improvement Program. And so they are true experts in every sense of the word. So I'm going to ask them if they would come now, speak to some of the other recommendations, and then we'll also have a recommendation from the juvenile justice consultant.
Mr. Milner, Mr. Kelly. All right, she's built you up to be something special, so let us impress us, I guess.
Yeah, we'll convince you otherwise here pretty quickly. Thank you so much, Chairman Wiggins, members, for letting us come and chat with you a little bit this morning. Just a little bit more by way of background. She neglected to say the most important thing, and that is, no, I'm not from Mississippi. Grew up next door in Alabama. Don't let this thick New York accent fool you otherwise. But I'm just making a mess. I'm sorry. Have had a chance all through the years to work very closely with folks in Mississippi. Have sat in on courts in different counties here in the state at the federal level. I was able to come down here and continue some work. Mississippi was the very first state in the country that we piloted a new federal child welfare review process. on in the mid '90s, and I was fortunate enough to lead that. And I was just thinking as we were sitting there waiting, not to belabor this, but when I got the offer to leave Alabama, I was the state child welfare director in Alabama before I retired from there. I was doing some work with the then commissioner of the newly formed Mississippi Child Protective Services Department. And one of the very first things I did when I accepted that job was to call up the then commissioner, Justice David Chandler at the time, and say, I need to talk to you about something. And I hopped in my truck and drove over to Biloxi, where he was at for a meeting, and just wanted to be able to tell him personally that I was going to be going to Washington, and he took that as an opportunity to have a hotline for any questions he had later on. But it's just been my pleasure to be able to see a lot of the work that has happened in Mississippi, and to share that as a peer who is from a state who shares a lot of the struggles, a lot of the same strengths as our president right here. I want to be clear in going through some of these recommendations that there is no shortage, in my opinion, both of strengths and areas where we can make a lot of improvements in our child welfare programs and our court system in Mississippi. And as I said, I've sat in those proceedings enough to have some sense, not as clear as this front row of judges over here has, about what happens on a day-to-day basis. But I'm not a stranger to it. And the recommendations are not designed to assign blame or to point fingers or to suggest that somebody's doing something right and somebody's doing something wrong. It's really about an opportunity to do better by children and families. And I'm making an assumption that that's why we're all doing the work that we're doing. We don't want to see those tragedies where bad things happen to kids. We don't want to see families falling deeper into a ditch that they can't get out of. We want to take advantage of whatever opportunities that are out there. I'll also say that even though 12 recommendations might seem like a lot, in my opinion, it's not a lot. We don't want to piecemeal you by coming in here today and saying we need this, and another day saying we need this. Many of these recommendations fit together, and together I think they comprise an opportunity for a whole system, court system here that can be as strong as it possibly can in serving children and very, very vulnerable families, help promote public safety, family and child well-being, and make it less likely that kids are going to start slipping through the cracks here, or continue in some cases to slip through the cracks here. So without any more rambling on my part, I do want to just start going through, and obviously feel free to stop me at any point and ask questions, or tell me to go sit down, or whatever. I would say we're starting with this recommendation that Mississippi have full-time dedicated trained judges and court staff as the foundation recommendation for all of this. You've got, let's see, I'll mess myself up here if I don't do this. As you all know, we got 3 different systems of court set up here. 24 county court, youth courts, 2 chanceries, and 2/3 of the counties here comprising, I think about 40% of the kids in foster care are under the jurisdiction of part-time referee courts who, from everything I've been able to determine, are tremendously underfunded and are not able to have the regularity of proceedings that are needed to ensure that kids coming into the foster care system and already there are having their needs met for permanency and due process. So I think we're not coming forward with a recommendation of a particular model at this point for what the court system should look like. But we are strongly recommended, and I believe that the Youth Court Commission overwhelmingly recommended that we have a unified system here that's uniform so that children and their families are not subject to the differences in geography, depending upon which court or type of court, I should say, that they land in. Their lives are at stake, and this is probably the most critical recommendation I think that we would want to make going forward here, and sets the stage for all the rest of them. Vicki has already talked about the uniform intake protocols, and so I'm not going to waste your time there on that anymore. I want to jump to the third one, which is incredibly near and dear to David and me. David and I were the leadership team for the Children's Bureau for 4 years. He was there much longer than me. But during that time, I would say the one thing that we did that we walked away with feeling the proudest of was allowing federal funds to be used to pay for high quality, independent legal representation for parents in the child welfare system. There are opportunities in abundance right now, and not mincing any words, in Mississippi as well as in plenty of other places around the country for due process rights of parents to get pushed aside when their relationships with their children are at stake, the very trajectory of their whole lives are at stake. And when that's something that's critical is before a court, they need a voice. They need somebody that's going to represent their interests, present fairly their strengths and what's needed to improve in their situation so that their children can live with them in a safe and healthy way. Before I go on to a little bit more about it, the words here, high quality and independent, I think are the key words that we're looking for here. There has to be a perception and a reality of fairness, that an attorney that's representing me in court isn't necessarily beholding to an agency or to anybody else. And again, having grown up in Alabama, where I know that everybody knows everybody in most all of the counties out there, sometimes those relationships make it difficult, make it a challenge for us to take a stand that sometimes might be different than what other folks think we should be doing. And so this concept of independence is actually baked into the federal guidance that David wrote himself, and that I was able to get passed through the clearance process at the federal government to provide those federal funds going forward. You've got the actual language of the policy here. We will use this one pot of money. It's called Title IV-E. It's the largest pot of money that the federal government has for child welfare services. Part of that money can be used for lawyers, not just for parents, but Mississippi already uses those funds for children and for agency attorneys. So it's a resource right now that I think is quite important.
We may be using, are we maximizing those funds?
No. You haven't started to
I see
use.
heads nodding no out in the audience.
Yeah, no, you're not maximizing the funds. Yeah.
Okay.
you're doing some really good things with those funds.
How much are we leaving on the table, so to speak?
I knew you were
Why?
going to ask me that question. Yeah, that's, and it's a tough one. It is a tough one to ask because you haven't jumped into the parent rep arena yet right now. So how that gets implemented would have a really big impact on how much you're able to draw down. I think I'm going to repeat myself for something that shows up later on the screen here, but right now, for every dollar that you invest in an eligible child's, the parent, legal rep for parents of an eligible child, you could get about 25 cents on the dollar back from I think I've heard people here call it a rebate, a federal rebate on that investment of funds for parent legal representation. Just as an example, not to set a benchmark for Mississippi, but a state that could be a little bit similar situated, Oklahoma, over the last since we implemented that in 2019, I think 2019 is drawn down about 20 million for that. You've got other states like Louisiana, maybe one or two of the Carolinas drawing down more in the single digit millions there, but they're all just getting started up with it. It's a new policy. People are still learning the ropes. And as David and I continue to work with the AOC and work with DCPS here, we hope that is going to be one of our primary focuses, is helping situate them to start taking advantage of those funds, because we don't want them sitting on the table. I got called into Congress to testify when I was there about why aren't states using more of this money that's available out there. When Congress passed the law, they intended for it to be used. And so we're happy to be here to help support that moving forward. Somebody looked like they might have a question. All right. Okay. I'll move on. Agency directed pre-petition assessment here is, this is one of the very critical things that I think sets Mississippi apart from other states in terms of the ability of the agency that your state is charged with protecting kids, investigating reports, to actually follow through and file those petitions in court. When there's a need to seek custody or some other protective action for children. And it's my understanding, I may not get this entirely technically correct, but in Mississippi, the judge orders that petitions be filed. Literally every other state in the country has provisions that allow the agencies to file petitions on their own. There are other states, you look at Carolinas, maybe Texas, I think, where the courts do review the findings of investigations before filing a petition, but the agency has that ability to go forward and file the petition.
You know, that leads me to a question. Why? So we as Mississippi don't do it that way, or the agency's not allowed at this time to file a petition? And then if we're that way, why are we that way?
Yeah. I don't know why you're that way, but it is statutory. And I think it's considered to be a safeguard. I'm not wagging my finger at this, but I don't think in the broader sense of things that it makes the most sense. You've got an agency that you're funding every year to investigate reports of child abuse and neglect and to make a decision about whether or not they've been abused or neglected. And my opinion, and the way I've seen this across other states in the country, the agency needs to be able to file those petitions and get the court involved as quickly as possible so that the court can then direct the most appropriate action for what happens. We're not trying to cut courts out of that, but in terms of process, it is something that would require, as far as I know, a statutory change to make that different. Any other questions about this? I knew this was going to raise questions, yes.
I'm sure somebody will come up with something.
I'm sure, yeah. Yeah, you look for me out in the parking lot when this is all over. Agency representation model was the fifth recommendation that the Youth Court Commission has made. You know, the agency is, I use the word party, not necessarily in the legal sense, because I don't know precisely what your statute says about who is a party to the case, but the agency that is seeking action actually has a tremendous interest in what goes on in the court proceedings and needs to be adequately represented in those proceedings. Right now, you've got a mix of some agency representation. You've got a prosecutorial approach here as well. We believe, again, that a uniform approach is probably the best way to make sure that the agency itself comes into court prepared, knowing what needs to happen, and can give the court the kind of critical information that they need to make decisions around what's going to happen in the lives of those children and families. And that is an agency representation model where you have got attorneys that are dedicated to full-time represent the agency as a separate legal entity who can file those petitions, who can work with social workers, caseworkers, to make the decisions, to help them understand what's legally admissible, permissible, and the right thing to do. The national legal associations, as you can see here on the slide, have recommended the agency representation model as opposed to a prosecutorial model. And I'll just use that to say that you're still probably going to need prosecutors because some situations, particularly those that might involve things like truancy, delinquency, are going to need a prosecutor to be involved. So it isn't a total replacement of the prosecutors in the process, but it is a way to make sure that we've got that consistent representation for the agency itself. And as I mentioned earlier, Title IV-E can help to pay for some of that. And I'm sure you're getting some Title IV-E dollars already for that. And we'd like to expand that. You got a map here of the states to show where the prosecutorial model is in the pink states there, just a very few of those states, including Mississippi, do that. The others are either a mix or a total agency representation model. All righty. And so for the next one, this is statewide diversion. I think I'm turning this over to one of the other consultants, Josh Weber.
Hello, can you hear me?
Yes.
Yes.
Great. Well, good morning. Thank you for the opportunity to be with you here today. I'm Josh Weber. I oversee the Youth and Juvenile Justice Program at the Council of State Governments Justice Center. If you're not familiar with the Council of State Governments Justice Center, we're a national, nonpartisan, nonprofit organization that works with all branches of state government as well as local government to focus on evidence-based, consensus-based strategies to improve public safety and outcomes for youth and adults in the justice system. Through our juvenile justice work, we've worked with more than half of all states across the country in helping legislators, courts, juvenile justice agencies align their juvenile justice policies, practices, and funding with what research shows works to improve public safety and youth outcomes. So as part of that work, we partnered with the AOC to conduct an assessment of how youth courts across Mississippi handle juvenile delinquency cases. So there's a lot of findings and recommendations that come out of that assessment. The one that I'm going to focus on briefly with you today is around the front end of the system in terms of who's referred to court and how those cases are handled in terms of kids that commit status and delinquency offenses. And you
Hey,
can see from this.
Josh,
Yep.
Josh,
Yes,
Senator
Senator.
Wiggins here. Just before you get into that, I want it to be clear for the members and the public. Y'all had worked, CSG had worked in Mississippi prior to recently. And this is me saying this. Generally speaking, what you found was frustrating. And it got to the point where y'all were no longer here. At the request of AOC and what we've been doing, in essence, y'all dusted off some of that, and we're trying to look at the things that need to be addressed. Is that a fair assessment?
I think that's fair. There was a decent amount of staff turnover within the AOC and with some of the judges that we're working with. There wasn't necessarily the same commitment that this AOC leadership has to really engaging the other branches of government in the process. And so we're grateful for the chance to be doing this work and to be hopefully working across all branches of government to come up with some consensus-based solutions to improve public safety in Mississippi.
Great, thank you.
So one of the key findings from the assessment was looking at who is referred to youth court for a delinquent offense in Mississippi. And what we found through that assessment is that the vast majority of kids that are referred to youth court have committed pretty low level or first time offenses. So you can see here a little more than 15% of kids are referred for a felony offense. Overall, only about 4 or 5% of kids are referred to court for a violent felony offense. The majority of kids who are referred to a court, almost 60%, are for a misdemeanor offense, and those are most often first-time misdemeanor offenses. And almost a quarter of referrals are for what's called status offenses. Those are offenses that are only brought to court because they're with kids and not adults, and they wouldn't be a crime if it was committed by an adult. So that includes truancy, it includes running away, and includes kids just generally being incorrigible and not listening to their parents. Next slide. So you can see in terms of the most frequent offenses, truancy, disturbing family peace, running away, simple domestic violence, most of the uncorrigible behaviors, most of the common offenses that kids are referred to are these status offenses, or they are family-based offenses. And so when we see data like that, that really suggests that kids have more service needs, family needs that are being addressed rather than that kids are a significant risk to public safety. And we always take a look when we work with states about who's being referred to the system for a couple of key reasons. Number one, research shows that lower risk kids who are involved in the juvenile justice system actually do worse than kids who are diverted. So kids who are low risk, who are involved in the juvenile justice system compared to their similar peers who are diverted, those kids are more likely to reoffend, more likely to be incarcerated, less likely to complete high school, and have lower earnings when they get into their 20s and 30s than kids who are diverted. So when we talk about these low risk kids, these kids who are committing first time misdemeanor offenses or status offenses, it's a better public safety strategy and it's a better education and workforce productivity strategy to divert those kids from further court involvement. Second, what we found in Mississippi was there's no statewide policies, practices, or criteria around diversion. And so youth courts are handling these cases in all kinds of different ways. And we see a lot of what we call justice by geography, which is a kid who looks really similar and commits a similar type of offense and has similar circumstances those kids might be formally adjudicated and placed on probation in one court system, or they may not be handled at all in another court system. And so there's really no sense of consistent best practices being employed. And then third, the other critical reason that states have really focused on diverting these lower risk kids is it frees up time, money, and resources for courts, for DYS, for service providers to focus on the kids that are actually higher risk to public safety. And so what we also found is that there really is a lack of programming for these kids, which is one of the barriers to having improved statewide diversion. Mississippi is one of few states that doesn't have any dedicated funding around services for kids involved in the juvenile justice system at all. And so services are really just based on like what's available in the community, and in a lot of rural areas, there aren't a lot of services, particularly behavioral health services, family therapeutic services, truancy reduction services. And so the challenge is not just a lack of state policies, it's also a lack of resources. Next slide. And what other states have found and what research has shown is investing in these types of community-based, evidence-based services give you a real return on investment. And so this is just some information around some of the most evidence-based programs and benefits versus costs. And what states have found is spending $1 on these kind of diversion services and more effective community-based programs gets you, 10 times, 8 times the return in terms of reduced crime, improved mental health, improved education outcomes. While you see at the bottom, Scared Straight, which was a more kind of punitive, accountability-oriented intervention, those kinds of approaches don't tend to work with adolescents. If you have a teenager, if you've been a teenager, kids don't necessarily respond to threats or to consequences. You got to address the underlying reasons that kids aren't going to school or got involved in the juvenile justice system. So more therapeutic-oriented programs have been shown to have a real return in terms of public safety benefits. Next slide. And so just to give you some examples of what that looks like in other states in terms of statewide commitment around diversion, Florida established in statute a statewide civil citation program for kids who commit low-level offenses. So essentially, statewide, kids who commit low-level first-time misdemeanor offenses, instead of being arrested at all, those kids get a civil citation from law enforcement. They get referred to the State Department of Juvenile Justice for an assessment, and then they get connected to services. And kind of an important point of that kind of intervention is then those kids aren't arrested, and so they don't have the black mark of an arrest for the rest of their lives in terms of having to report that information on a future employment application or college application. So it's a way to still hold kids accountable and get kids into services without an arrest. Oklahoma, another example of a state, by statute required that all kids who commit a first-time misdemeanor offense are automatically diverted from court involvement. And they set up regional kind of local youth service coalitions to provide a range of preventative services to kids who are diverted. And that's one of the challenges in Mississippi is there is no formal structure or funding for diversion services. And so kids have to get involved in either the child welfare system or the juvenile justice system to get services. And then that's a lot of time, money, and other things wasted rather than building up a network of prevention services. In Kentucky, somewhat similar, diversion is statutorily required as the presumption for all kids who commit first-time misdemeanor offenses. And Kentucky set up regional multidisciplinary teams that includes representatives from child welfare, juvenile justice, education, and behavioral health to assess kids and connect them with appropriate services. And then last example, which is Utah, which Utah basically restricted all kids who commit status offenses from being referred to court, like truancy. And instead, they established a statewide network of 11 youth service centers that provide support services to youth and families. Legislature appropriated $9 million, and they serve over 3,000 youth statewide. So really, recommendation is to strongly encourage two things. One is for Mississippi to establish at least some minimum statewide guidelines and statute and criteria for who should be diverted out of the system and better connected to services, and ideally appropriate at least some resources for specific programs and interventions that can serve these kids and meet their needs. Happy to take any questions on that.
You're good. Next.
Yep.
All right, I'm gonna move on with our
Oh, I'm sorry, Josh. I'm sorry. Josh, thank you very much for that. I know there may be some other questions as either we go forward or, after this hearing. So we will be talking. Thank you.
Thank you. Appreciate it.
Hey, thanks. Next recommendation I wanted to mention is recommendation that the youth courts actually be the only option for truancy situations. Right now, you'll see that you've got, I'll skip ahead to this one. You've got truancy being handled in 3 different courts: the Justice Court, Municipal Court, and Youth Court. A survey that the AOC conducted, one school attendance officer reported they don't bring truancy to the youth court. Some of the youth courts report that they're not handling truancy in their courts. And this is just a map of how that falls out. By far, most of those referrals are going to the youth courts right now, followed by referrals over to the Justice Court. And a few of those actually go to the municipal courts. I think the importance of this recommendation is having just one court that has jurisdiction over truancy, which I know a number of people in this room are real concerned about, gives us the opportunity for some consistency in how those are handled. We've got, some of the courts, perhaps the justice courts, municipal courts, who really, those judges are not really trained in issues around truancy, and to keep that, hopefully keep that from escalating into much more serious areas as a preventative measure. We believe that the consultants have believed that consolidating that under the youth court jurisdiction was the best way to go.
All right, Mr. Miller, I got some questions.
Okay.
Because as I mentioned, the lieutenant governor, and he knows the stats better than I do, as does Chairman DeBar from Education, about what our truancy numbers are.
Mhm.
And so if we can go back to the previous slide, or no, maybe it's the next one. I'm sorry. The next slide.
Yeah.
So my question is, and so as the lieutenant governor's staff has been looking at this, the question has risen, why have truancy cases not been either prosecuted or brought to the attention or what? And now I see up there 6 youth court judges, referees say they do not handle truancy in their courtrooms. Do you know why that is?
I'm going to have to rely on somebody else. We don't know.
Maybe the judges, huh? Sure. Yes, please. I think
Yeah.
got people on. Or yeah, if you want to sit right there. Thank you, Judge.
One of the issues is that we have referee courts that are not funded. They are outshoots.
County-based funding system, correct?
I understand that, yes, but they are also appointed by the Chancery Court system. These referees struggle to have the funds to have court even 1 to 2 times a month. Take me, for example. I have a court that on paper needs to bring 2,500 children on a truancy charge in Lake County. That's more than any caseload that a chancery court has with 4 judges. You relate that to a very high population of a referee court. I can't do it. It's not that they don't want to. They cannot do it. And they are getting contacted right now because, truancy is a great topic that the Senate is being put in. And I hope that we continue that conversation. But they're calling and saying, Judge Bethel, I can't have those days. I do not have the funds to pay my lawyers. I do not have the courtroom space from Chancery and Circuit because I'm having to share that. I don't have the money to pay my attorneys. I make $20,000 a year. I can't do it. I want to. Help me figure this out. And that's why I'm going to say 6 is probably low on that number. But I want everybody to understand this is not an unwillingness. This is, I'm not able.
And
Whoever funds us.
yeah, and is that, as you said, in the referee courts? Or is it all the courts?
There are county courts that do not have the funding to have that. 2,500 cases need to come through Lee County alone
Of truancy.
of truancy. I'm a have in
Yeah.
this system. I'm a have.
So how are
Have
those,
money.
yeah.
Can't do it.
So how are those being handled in Lee County, for example, then? If there's 2,500 that need to come, how are those being handled?
They're being sorted through, they're being prioritized. We have an informal system that we run all children. We start identifying them when they have a lower number of truancy absences, because when it comes to 12, you're supposed to bring them to court. We start trying to identify them with the courts, with the school systems at about anywhere from 5 to 10. And we start trying to send them, we have a program called ASAP, and we send them a letter, ask them to come in on an informal basis. We try to, they may have drug issues. They may have poverty. It may be a single mom that can't get their child to the bus stop because they're afraid to let them walk down the street after they go to work at 6 a.m. There are so many issues that are societal issues that work into truancy. And they're very hard to sort through. It's not just yes and no. We have a walk zone around our schools. We have kindergartners that are supposed to walk to school. There is no mother or father who is not at work, and there's no bus to pick them up. I wouldn't let my 5-year-old walk to school either. There's all these different reasons, but to say that they don't handle truancy, there is not a youth court judge in the state of Mississippi, and I'm saying that with all of my conviction, that don't want truancy to be handled, because if you handle truancy, I don't have to see them in delinquency. I don't have to see them in CPS court because they're getting the services before they come to me. Truancy is the true diversion that this state needs to invest in. I believe that with all my heart. I've been doing this for 8 years. Hope to do it for many more. But our population is already identified.
But, and I think y'all testified to this committee, I guess that was last year or whatever, that truancy is an indicator of all the other issues that you end up
Definitely.
having to deal with.
Definitely.
Okay.
Definitely. I would like the opportunity to address at the end, if there's any way, it would just be 5 minutes to share some things. But this was one of the things I wanted to address, and thank you for letting me do that.
Yeah, and on that note, I was thinking, we do want to hear from the judges and the agencies. I don't know, and we can look at scheduling another meeting on this where we can hear from that. It was a lot. So yes, we can, if we have time on that, to hear from y'all, Judge. But I certainly am open to having another hearing to hear from the agencies, the judges, and all on these issues. So, okay. And then I guess she answered my question, because I was going to ask why 19 courts have not received a truancy referral. Do we know why that is? I guess Vicky has the answer for that.
I have a partial answer. We don't have enough school attendance officers to do the work to investigate the cases to then make a referral if needed to the courts. So some courts may be willing to handle truancy, but they're not getting any truancy referrals from MDE.
I don't even know this answer, but since this is a Senate issue, apparently, have we talked about funding additional truancy officers? Do y'all know that?
It's my limited understanding that MDE does have some proposed legislation.
AOC has? How many? Okay.
And-
Our crackpot budget folks are saying, yes, MDE has in a request for truancy officer
And-
additional, so
And
that's
two,
a good thing.
I'm sorry.
No, go.
Just real quick, I wanted to mention, I know Chairman Wiggins, we've talked about this, but just so all the members of the committee know, leadership from multiple agencies have been meeting on a monthly basis, all day in person, to try to address some of these issues. Because the child welfare system, the juvenile justice system, the youth court system, these are big systems and they implicate lots of agencies. So OSPD, CPS, DHS's Division of Youth Services, the Youth Court Judges Council, we've been locking in once a month and then conferring with additional agencies, Medicaid, education, mental health, trying to wrap our heads around what the solutions are. Sometimes I feel like a first semester law student, we can spot the issues, right? We see the problems, but then trying to craft the solutions is going to take a lot of cross systems collaboration. And they've been doing that work, and then we're conferring with the consultants and then trying to bring to you as the decision makers some possible solutions to address what are really multi-layered, very complex problems.
Okay, that's it for my questions. Any other truancy questions? Okay. Back to you, sorry.
All right. I want to go on to the eighth recommendation here, which is for expanded and dedicated prevention programs and services. This is absolutely essential if we're going to address court workloads, if we're going to address foster care caseloads, which are growing in the state right now. Having adequate prevention services is one of the essential agreements or ingredients, I should say, to having that in place. Also, when David and I were at the Children's Bureau in Washington, Congress passed the Family First Prevention and Services Act, which does provide federal funding for prevention services, but only for those kids who are literally at the front door of walking into the child welfare system, the foster care system. A child has to be declared to be at imminent risk of entering foster care in order to qualify for those services. States have been working very hard across the country. About 40-something states now have submitted plans under the Family First Prevention and Services Act to get the federal funding for those prevention services. I'm very, very happy that the Mississippi Department of Child Protection Services has recently gotten approval for their Family First prevention plan, which will now allow them to begin drawing down some of those federal dollars for a portion of the prevention funds. The feds will reimburse for half the cost of providing those approved services. Too much information probably, but next year that rate will go up to the federal Medicaid agreement rate that is in place in state, which is probably a little bit more than 50%. I don't know what it is right now, but Mississippi submitted a plan for 6 prevention services for those kids who are at risk of entering the foster care system. They'll provide things like home visiting, for brand new moms, some of whom are very, very young, don't have a lot of family support, are at high risk of losing their kids to the foster care system. Some intensive in-home family preservation services. Home Builders is a nationally recognized model with all kinds of research backing it up. Services that are designed to stem aggression in young people that are placing them at risk, and some other services there. I think once we're able to really begin full implementation of those services, that is what's going to be needed to stem the flow of kids into the foster care system. And there's all kinds of research and studies out there that show that investing in prevention is a much cheaper way to invest money than investing in foster care for kids and families who didn't have benefit of those services. I'll briefly mention that again, the Family First services are for those kids who are already at high risk of entering the foster care system. We can get even more bang for our bucks if we put into place community-based family support programs that can help to divert kids from child welfare system, intensive mental health systems, and juvenile justice systems. Josh made some reference to that in his presentation, and in much of our work, David's and my work around the country, we see those community-based programs really filling in gaps in the place of much more expensive formal services. Any questions about that? I believe that Vicki has already made reference to a uniform crossover protocol here, so I won't spend too much time on that unless there are other questions around having a uniform system for addressing kids who are both involved in juvenile justice and child welfare. Perfect. Yeah, and Clay has already addressed the technology. You may get your wish, Chairman, and we'll get out of here a little bit early. Got a lot of slides. Last one, or next to last one, is access to justice. There's been some discussion already about having full access to court records. Which is tied to the updated technology that we've already spent time talking about, making sure that attorneys have the supports that they need in order to provide those services, and that all parties have full access to the records that are there. Again, a lot of these recommendations are very closely intertwined, and one directly impacts the other. The last recommendation here really is what I've already made.
Can we go, I'm sorry, can we go back to that,
Yes, sir.
that first point? Must have full access to their cases in youth courts, including copies of all orders to protect the fundamental rights of families. Did y'all happen to look at, let me back up with this. It's no secret there is a issue in this state because we've had bills on it, and in our Judiciary A committee, we get bills filed every year about access to records in youth court by attorneys, by DA offices, and it's a source of back and forth. Did y'all happen to look at that? and you know which statute I'm talking about?
Mhm, mhm.
The
Yeah.
disclosure of record statute?
The consultants have not looked at the confidentiality statute specifically. The recommendation here is really focused on ensuring that parents receive copies of court orders.
Well, that's my point. I think we amended the law a couple years ago to allow parents and their attorney. We keep amending laws, that law, so to speak, because throughout the state, different places interpret the law differently and choose and say that either the parents or the attorneys or whomever can't get access to the orders, or they have to sit at the courtroom and get that. It's different everywhere. So
And
there are
currently,
people who are being denied that, which is why we've had to amend it.
and attorneys have also raised a concern that if they're pursuing a case on appeal, they can't access that record virtually. They have to go to the courthouse and sit with the record to work on the brief. So we do have some access issues.
Wait, you're
Um,
saying an attorney who's doing an appeal of a youth court case has to sit at the courthouse and do the appeal brief there because they can't take the records
If,
with them to work on their brief, and those take a lot of time and effort.
if the record has been transferred to the appellate court, yes, that is correct. They have to sit in Jackson with the record.
Jackson.
Yes, which can be challenging for attorneys across the state to have that kind of access and time to have
Why are
access to
they-
the record on appeal.
Sorry, why are they having to do that?
Because it's treated as a sealed case and there's not a carve out that would allow them to access it another way. So one of the challenges that we currently have is that in Mississippi, we have closed courtrooms and sealed records. But our technology does not allow for you to seal an individual case. Our flip phone technology can only allow for someone to have county-wide access or statewide access, which is a bit ironic in a system that has what's called by some double confidentiality in the sense that the courtroom is closed and the records are sealed. So we have some technology limitations there. Some states, the trend is moving away from confidentiality. Georgia recently opened their courtrooms and opened their records and said that it destigmatized juvenile justice and child welfare proceedings, and that children and child welfare proceedings, often it opened up additional placement opportunities because relatives and fictive kin would be present in the courtroom and hear what was going on with a child and step up and offer to foster that child. The cases that Georgia says that they now seal tend to be juvenile cases where a juvenile has committed a crime that there are concerns about that being public and following them for the remainder of their lives. So they have seen a benefit from lifting confidentiality. I'm not advocating for that. I'm just saying that I think that warrants further study because we are seeing a lot of changes across the state. There are not as many states that have both sealed records and closed courtrooms. We're one of those venues, but there is a national trend toward moving away from the confidentiality.
Okay, thank you.
The last recommendation I'll address, we've already really touched on this in a number of the other recommendations. We've made reference to Title 4E of the Social Security Act, which is, as I mentioned earlier, the largest pot of money at the federal level for child welfare services in all of the states. Most of that money goes to reimburse the cost of foster care, adoption, guardianship, admin cost. It's a cost reimbursement program, so there's always a state match that goes along with that. As I mentioned again, in response to a question much earlier, on the legal representation itself, legal rep for parents. From the time we implemented that in 2018, 2023, just some examples of the amount of money that some states in this area have drawn down. Again, these are approximate amounts, and states are actually still in the process of setting up their processes for drawing down those federal dollars. And that's where David and I hope to be working for with the department here and with the AOC to make that possible in Mississippi. In the last 3 years here nationally, over $300 million have gone to states as the federal share for that 40 legal representation. And I believe that actually concludes our recommendations. Any questions or comments? Happy to take them.
Any questions from any member? Nope, I see none. Thank you very much for that. Thank you. All right, moving on. Do we have, do we have Rhonda Serrano here? I just want to make sure the ones that if we have that are on standby, we get to them.
We do. Jerry spoke to the child welfare specific recommendations, but Rhonda's also available if anybody has any questions.
Okay, so that was on the same. What about Betsy Fordyce?
Betsy Fordyce is another consultant that we're working with that she is what I call our quarterback. She is helping us identify the sequencing of these things because none of this can be done. This is not a light switch kind of change. We can't just flip the switch and do all these things. But taking into account where we are in different things, where we are in youth court, child welfare, and juvenile justice, and she's meeting us where we are, helping us with all of the assessments. So right now, just to be clear, there are 4 system-wide assessments that are been done for youth court: the technology piece, my kids audit, an assessment of crossover youth who are involved in both child welfare and delinquency proceedings, an assessment of the child welfare system, and an assessment of the juvenile justice system. So Betsy is working with all of those consultants to help us layer and sequence how to implement those improvements if possible.
Well, okay, thank you. What I'd like to do then, I think we have we have 20 minutes left. I would like to hear if they so choose. I see our officials from DHS, CPS, and our judges, if they would like to make a few comments on that, and then
Great.
On these recommendations while they're here. So not to say our consultants aren't important, but I think we've gotten the recommendations. So thank you very much. So Judge Bevel, I will allow you to address it, and then would CPS and DHS and any other, I don't want to open it like floodgates, but but the agencies were addressed. So
Thank you.
okay.
And I wrote my comments so I could be as brief as possible. My name is Judge Stacy Bevel. I'm the county court judge from Lee County. I served as the chairman of the Commission of the Uniform Youth Court System and Procedures, and today I also stand here as the chairman of the Council of Youth Court Judges. I became involved in this legislative process now 3 sessions ago when Nicole Boyd called me at a softball game at 8 p.m. the night before and asked could I be in Jackson at 9, 3 hours away the next morning to help with the youth court ramifications of the baby box bill. Judge O'Neill and I moved dockets that day and came. We plus others in this room have come every time he or she has been asked. We tried to share the view from the ground floor looking up and out of the system. Many of us here have almost 2 years on a commission outlining an honest, unbiased look at a system that woefully is underfunded along with structure recommendations. Historically, we are not the first to advocate for these system changes and will not be the last. 2 men, Mr. John Hudson and Tom Broom, along with Chief Justice Waller, asked repeatedly for system changes, and they have had no avail. This now has dated back over 30 years of ask in this capital, and I pray there will be many more that will speak for the families of the state we serve. I watched the narrative change when the report was rendered, and I feel like much of the hard work and data collection sometimes was tunneled to highlight the inefficiency of the judicial officer of the youth court instead of the system as a whole. I will stand here today before you and own our part of the chaos. I completely, unequivocally own how our siloed structure can sometimes lead to inefficient outcomes. However, this session, I cannot be silent, though, and continue for our judiciary as a whole to be cast in a light as if we get up every morning and we try to do harm sometimes and do not do our jobs. There will always be one-offs. We all know the stories in this room, and you're contacted about them. And right now, I will go on and say that many of them are unexcusable, but to speak to a group of judicial officers as a whole is no more valid than for me to pick the behaviors of a few legislators and attribute it to the body of the whole. I want to take a zoomed-in look just briefly at a couple of these judicial officers. I would first take myself. One of the 3 largest county courts in the state as far as volume, Lee County averages 180 to 200 abused and neglected children in CPS custody, with another 80+ in in-home cases monitored by the court and the agency. We have about 60 kids on probation at any given time. And I serve a school system of 14,000 children in 3 school systems attending schools on 32 different campuses. Per the statute, I should bring over 2,500+ children to court for truancy. That docket alone is larger than the top chancery systems in the state that have 4 judges. I have some type of court 4 days a week, 3 school attendance officers, 3 DWIS counselors, and a functioning CPS. We are starting an intervention court, and I have great community support. I make the statutory maximum in salary, and I have another judge to cover the civil and criminal portion of my docket. I am part of the haves, but still face an impossible expectation every day to meet the task laid before me. As to funding, I'm a county court. From the state, I receive $68,000 in state farm youth court support funds, and excitingly, I am now getting $100,000 from my newly formed intervention court. The rest of my most $2 million budget that includes a detention center comes from my county. The second judicial officer I want to highlight is the 56 other counties that have part-time referees, many making substantially less than even a justice court in their area, which could be as low as $20,000, with little or no staff. You will find a referee and a part-time attorney, an attorney in a private practice that is paying or supplementing from their own payroll one of their own employees to be the intake officer, the designee, or the court administrator. I had a referee laugh and tell me that they consider that their tithe. Fighting for space with other courts, fighting for space with other courts to have their hearings, having to coordinate to get around the circuit and chancery courts, begging Board of Supervisors to pay a parent attorney, a public defender, or a GL a wage for them to take time from their practice needed to do the jobs, being told they have one more court now, and now conversations about what we're supposed to do with covering truancy with just the budget we have. You will find counties with no detention centers, limited or no access to proper juvenile mental health services, or community resources to help the children or families when they do become court involved. You will find counties that have no technology equipment or access to a budget now to replace the outdated or technology that was recently taken back from the state. You will have a referee that took the bench and was offered no best practice training, no budget to seek such training, but is invited to an annual youth court conference, only one, to try to get what they can. A referee court is appointed by a chancellor, and many times all they get is the court order that gives them the position. There are no funds from the chancery system that follow them, and many times no acknowledgement that the referee court is an extension of the chancery court. There are already state chancery courts here in our state, and they're given $15,000 a year by the state to function from youth court support funds. A court system from a full branch of government in 56 counties given $15,000 each a year from the state to operate. No wonder we are where we are. My point here is that while we are all quick to judge that person wearing that robe, it is very heavy. and is an impossible job with the resources given, even for many of our county courts. Our state must prioritize funding for our youth court system. The latest appropriation bill gave $55 million to run the circuit and chancery court systems, with only 2.5 going directly to the youth courts in the support funds. That's just not acceptable. Many of you told me not to ask for additional funding until we made improvements on ourselves being the judicial officer in the way we run our courts. And I want to end this report with a report of our efforts. We have organized. As allowed by statute, we have established and restructured our Council of Youth Court Judges. We have an executive leadership board along with officers that are taking places at tables such as the Core Four that you have talked about in discussions today. People know how to reach us. We have a clear communication, which is basic, but it was lacking. We have complied with state mandated intake training for the judges and our intake officers. The Judicial College reports over 90 people have been trained. AOC is further expanding that training, and we look forward to many more positive improvements. We are partnering with other organizations to gain financial and educational opportunities, not just coming to the state. New Allies, which is the philanthropic arm of Youth Villages, just awarded grants to 5 youth courts to improve best practice. One is to highlight that is Jackson, Hancock, and Harrison counties are now developing a plan of safe care system for the coast to engage community partners to ensure the safety of children. Another one is from the Delta, a family engagement initiative. And Marion County, with Judge Porter, was granted a social worker to help with her safety plan docket. Another exciting thing is the National Council of Juvenile and Family Court Judges is also coming in December at no cost to perform a state-specific best practice 2-day training. To conclude, everyone here must acknowledge that we are all fighting the same battle, a society with needs and challenges that are changing faster than any of us can keep up with. But we all do this with limited resources. Mississippi is a state of limited resources, but funding for our youth court system and services for children must be prioritized this session. I want to thank everyone for all the work that's been done. Vicki, you've done a really great job. And I would like to highlight a few of those that were brought up here today. Direct funding for proper court administration is crucial. I don't have to repeat myself. You have a whole commission report that talks about that. Funding for a lawyer representing CPS in every single courtroom. Funding for OSPD to provide indigent representation in counties that don't have current representation. We have counties that they do not have public defenders for people. I didn't believe that. But we have those counties, and it's not intentional. It is the lack of funds. Access for placement of children with very high acuity behaviors and mental health needs. This is debilitating all of our agencies and our systems. And we ask you to immediately set up a study committee to survey what resources the state currently has and ones that we need to implement. CPS is not a hotel, and we cannot continue to act as such. Lastly, to fund DYS to give struggling counties statewide diversion options. Our funding source for DYS is housed in the Department of Public Safety. I'm not understanding why that is so, and I'm not going to pretend to understand all of that. But I think that if we possibly can get that moved, then we might have a little more traction to give away some money and to have those diversions. I encourage you to support all efforts to prioritize truancy, but recognize that without additional funds, existing courts cannot add needed court days to handle the resulting caseload. You asked about the referrals and why you'll see some counties. Judge O'Neill looked at me and said, it said 0. Well, the problem with some of our data is that truancy can be put in legally. This is not something somebody's doing wrong. The statute allows you to put it in as a truancy charge. The statute allows you to put it in as incorrigible and governable behavior, educational neglect. It is 3 or 4 different ways that our statutes address truancy, and I totally support that youth court, even almost as an intervention model, can take up truancy in the coming days. My last thing is that I would ask to change the narrative this session and use these recommendations given today and the ones from the commission report to guide us on our next step forward. I thank you for your opportunity to address this group, and we look forward to working with you in whatever way we can.
Thank you, Judge Bevel. I think that was That was well said. And first, let me say, on behalf of the committee, everybody does appreciate the work that the judges have done, that the youth court judges, the workers, everybody, from the lieutenant governor's office to the speaker's office, everybody appreciates that. But and as you indicated, these issues have been around for 30 years. I mean, there's the recommendation for a statewide youth court was made. It wasn't us. It was made 30 years ago. And the legislature bears responsibility for not doing the things that you've said. I've said that. And I am glad that Lieutenant Governor Hoseman, the Speaker, and the House, we've been looking at this because of the issues that we have. And you're right, it's a state issue that we all need to be working together. And I think we're getting there. And so just know, if that was the narrative, that wasn't the narrative about, it's the judicial officers issue. It was that we need to do something for our children. And I'll say this, that this state has been rocked by the shootings. In the last 2 weeks, I've gotten personally more comments about that than the budget of the state of Mississippi. And by the way, we had a shooting in Goche in my district. And I sat there and talked with people like, what are we doing? Or how are we in this situation? And the news reports, I mean, are you kidding me? We have tailgates at homecoming and we got people shooting each other. That's crazy. And it's kids. We cannot go around and think that what we're doing is working statewide. That's why we're doing this. And what I've heard here today, Mississippi, we need to fix things. The lieutenant governor, I know he said that, the speaker, and we are doing some things right. We have the most caring people in the state. And honestly, probably in a big way, the legislature hasn't given y'all the tools that you need to do what you need to do to keep kids from shooting kids at homecoming. And probably part of the system is, I think us who practice in there understand it. Our average legislator doesn't understand it. I'm sorry, I turned on Super Talk this morning. Did I hear him talking about this? No. Do we talk about these things? No. Does the media talk about it? No. What do they talk about? Yeah, we're going to talk about school choice. There's an element of truancy, but we talk about all this other stuff when it's kids shooting kids. Maybe we need to start talking about what works and the people that are doing it. Judge, you got me preaching now. But it's necessary to look at these things. And honestly, the data, the system that we have, it's not working to the benefit of our children. And we've got to do something. We can always do better. We talk about the Mississippi Marathon. We're doing great in that. No, it's the miracle. But as the lieutenant governor said, we put our feet down and we worked for 10 years before people started recognizing that it was a work over time and it didn't just happen. So my point is, nobody's trying to cast aspersions, but we are trying our job. And I think I can speak for Senator England and for Senator Boyd and for other committee. We were elected to do things better than what were being done in the past. And it takes all of us. And so that's why we're getting into these things. That's why I appreciate AOC bringing these recommendations to us. I mean, and I'll say this, if Chairman Hood had not put forward the bill about the My Kids audit, we wouldn't have heard about this. And now when I got that, what I've heard is, as Vicky said, we're dealing with a flip phone for our children. I mean, there are things that are important. So, I appreciate Chairman Hood for bringing that, and we talked about it. So I hope the House will take this up as well. And to be honest, I've said that $8 million for a new computer system. Heck, we've spent $40 million for one phase of a new computer system somewhere. So I appreciate that. And yes, the work that people do, and I will say this, I don't think people do not understand what youth court judges, what intake officers, what they do. They don't. They only know it when your kid goes there and then nobody wants to talk about it. And I think this state needs to understand what y'all do, because that's the only way we're going to be able to fix it for y'all who are in what I call the trenches, as you said, Judge. So I appreciate that. And yes, the narrative needs to change because it's all of us. And I'm fine in saying if the narrative needs to change, it needs to say that the legislature over the last 30 years hasn't done anything. And that's our fault. And if I may say, we're trying to do something in Judiciary A. Thank you for letting me preach there, Judge. You got me started. But I'm sorry. We could. Yeah, that it most definitely is. And when the session starts, we could do that. I will talk to Chairman Hood and Chairman Horan about us doing that. But the Senate has been on this for a while, as y'all know. Lieutenant governors made truancy a huge issue, which personally, I didn't know this was going to be like that big of an issue in this setting. So yes, we can talk, and I'll talk with them and us try to have either a hearing and get the judges and all that together. But before we're coming up against the time, I did want Commissioner Sanders, if she wanted to say a few words. And then Commissioner Anderson, be careful, you're going to get me preaching again.
Thank you, Mr. Chairman. First, I'd like to say amen. Amen. And I'd also like to say I did not prepare remarks. I've made a few notes to add comment to what's been said. But I think I'll start with saying something that I think is really important, and that is that there's not one soul sitting in this room who's here for any reason other than they are extremely deeply devoted to making the future better for children in Mississippi. So, I represent the agency that has long borne the responsibility for what happens to children, borne the blame, and also borne the liability. And I've found that it really matters for me to back up from that a little bit and look at data, best practices, and stick to reforming the system itself. If I only make changes that are dependent on Andrea Sanders being here to ensure that they happen, it's all going to fall apart when we have a new leader. So I really commend it. It's terrifying to think about change. Change is hard. I commend Judge Bevel. She and I have had a great relationship. We share information frequently. We text, and we don't always agree. And we acknowledge that. We respectfully don't always agree. But the judges have come to the table. The AOC is a fundamental part of bridging what is a necessary nexus between child welfare, youth services, and the judiciary. So two executive agencies and the judicial branch. And you really can't have good outcomes for kids and youth in Mississippi without that nexus being clear and consistent, and addressing the system-wide issues that have plagued all of us. So to the points that were made earlier, I would just point out that my kids, the Microsoft platform that they're talking about building it on, our agency is already building our CWIS product on Microsoft. It truly is possible with a small investment, relatively very small investment, to create a system that encourages and makes it easier for everyone to use the system the same way. And that's the way we start to get data that really helps us understand how do we need to shape this system. The ability to communicate with the agency system is already a requirement of the federal dollars that we're drawing down to match our project. So I would strongly encourage investment in that part of the system. Agency representation was brought up, and there are two things I would clarify about that. One is the agency representation model is different than the agency having attorneys, but it's dependent on the agency having attorney. The model, just for child welfare, would have the agency bring on the petition, lay out the evidence from the very start of the case, so that we, if you'll recall, I laid out the 3 parts of the case in Mississippi. If we bring on the evidence early, ensure due process for every parent, and that is a matter of parent rights and doing what's good for families, but it's also a matter of moving kids to permanency efficiently. If we don't get due process in the early phase of that case, and that's all dependent on how the prosecutor brings on the case, then you can get to TPR and never have the findings that are necessary to move that child to permanency if that's what needs to happen. So I strongly advocate for agency representation. Mr. Chairman, you'll recall me coming to you 4 years ago and asking to clarify that the agency is in fact a necessary party in Mississippi. That was a foreign concept at that time, but we're the agency again that holds the child, that's responsible for the money spent on the child, and that bears liability. My name is on the Olivia Y lawsuit as a defendant. My deputy is a defendant. And so we have to have that level of consistent representation in order to ensure that we're not violating children's constitutional rights or parents. Maximizing 4E. There is absolutely room for bringing more dollars into the state. That's the whole reason that, well, one of many reasons we're working with outside consultants. The agency has already taken steps that put us in a good position to continue to maximize those 4E dollars. We separated from DHS, set up a cost allocation plan that's specific to 4E. It is an extraordinarily complicated federal funding scheme. And we've been able to raise our rate of kids that are found eligible for 4E dollars, which I won't even go into explaining all that. You and I've talked about it before, but from around 28% to 45% today. It's a huge increase, but there's room to make it to go higher. And I believe that the children in our state deserve every single cent that I can bring into the state from any source to improve their outcomes. Truancy, I would just say on the matter of capacity for hearing truancy and the funding that it would require, I would beg you to consider that these children are being handled now as educational neglect. So they're being handled through the most expensive and invasive part of the system that they can be handled through, which is child protection services and/or, as I think Judge mentioned, some go through. Anyway, so there's room to clarify in the statute how they're handled. It is a fantastic opportunity for Mississippi to invest in prevention and start diverting kids before they get to the point where CPS really, truly should be involved.
And while you're on that, I did confirm with the budget that MDE has requested at 1.5 million for truancy officers.
And I would fully support that ask. I would also encourage that we consider systemically how those truancy officers fit into this greater system. We are talking about trying to really fix a problem here and not chip away or kick it down the road. And they've been considered an afterthought in the past or a sort of sidebar. It's fundamental to this entire system. And finally, I would just clarify on lifting confidentiality. I don't think anyone's encouraging that we advertise who's in foster care or who's involved in the youth court. That's not what we mean by lifting confidentiality. But in Mississippi, that has become a sealed court, closed court, and sealed record. And so I would encourage the state to give courts the authority to use the tools they already have. Courts know how to view things in camera. They know how to close hearings when it's absolutely necessary. We know how to use initials in pleadings. So I'm all for keeping it confidential who's involved with the court, only to say that I have to tell the school and everyone else who's a foster child so that I can get the services and care for them that they need. So I don't know that we're actually keeping it confidential who's involved in youth court. I would just wrap up by commending you and this committee for taking time to listen to these complex issues. And, I want to thank the judges for taking time to be here. I guess you're missing your conference. But, and to reiterate that more hearings like this are necessary. And while it doesn't seem like it's really a Jud A kind of thing to start talking about continuum of care and what's missing in the state, a holistic approach between the Senate and the House and probably expanding into mental health is what's needed to solve this problem. So thank you very much. I appreciate the time.
Thank you, Commissioner, very much. Commissioner Anderson? You're our last speaker, so leave us wild.
I'm just a simple executive director, Mr. Chairman. I'm not a commissioner.
Oh.
So I will be as brief as I can. I do want to reiterate what has already been said by several folks, and I'm glad that this first recommendation is on the screen because in the group where we had met together, they've heard me say this already, and I implore this committee, your counterpart in the House, and everybody who is concerned with youth in our court system, that we absolutely make this first item your first priority. Although I would add, it should read full-time dedicated, fully funded, trained judges and court staff, because everybody agrees we need that. And I'm going to go one step further and say, I think we don't need to be kicking around the three options. We need a youth court system that looks the same in every county and not be talking anymore about all these three models. We need one youth court system. Now, I want to talk to three other recommendations that are here because they touch on the work that the Division of Youth Services, which is part of MDHS, has direct involvement with, and I'll be very brief. Recommendation number 4 talks about agency-directed pre-petition assessment. And as a former prosecutor, I just have to say, I believe the decisional process about which cases result in petitions needs to be with the executive agencies first and foremost. They need to make that decision. CPS needs to fully investigate cases and decide which ones need to have petitions filed. DYS, along with law enforcement, needs to have the opportunity to fully investigate every allegation of delinquency of criminal conduct before there is a decision made to involve that child in the court system. I won't say any more about that. I've already talked a lot about it to these folks, and they know my views. Statewide diversion. I'm just going to repeat what I had been saying for 4 years. We've been asking you for adolescent opportunity program funding for 4 years. I've come before you every year. I've asked the House for that funding, and I've gotten none for the last 4 years. Statewide diversion is really, it's the state deciding what is our model going to be for this court system. It's a choice between prevention, rehabilitation, and probation, all of which go together, or detention, really incarceration and punishment. And if we are going to benefit the children, if we're going to act in the best interest of the child, I think we absolutely as a state have to invest money in prevention, rehabilitation, and probation. And the way DYS has suggested it be done, it will be a statewide oversight model, but it has to be a county-wide administered process based on the resources that are available in each county and based on us being able to give resources to every county so that they can have a diversion process. You know, if we don't have options, we don't have diversion. It's as simple as that. We have to have options. And then lastly, this is really the same idea. Recommendation 8 talks about expanded and dedicated prevention programs and services. Prevention and diversion are both, they're different sides of the same coin. They're the same idea. If we can prevent children from getting involved in the child welfare system or the juvenile justice system, their lives are going to be better. It's as simple as that. Nobody can dispute that. And I will conclude by reminding you, we've shared this information with you each year. The cost to incarcerate in a detention center for a year, a child in Mississippi, is approximately $155,000 to keep a child in detention for a year at Oakley Youth Development Center. If we had community-based and that comes out to, I think it's about $300 a day. If we had community-based programs, we could administer those, we estimate, at a cost of about $75 a day and save the state hundreds, yea, millions of dollars. So I will applaud you again, Mr. Chairman, for calling this hearing. I hope that your counterpart in the House, as Judge Bevel has said, will hear these recommendations and we'll hear from these parties as well. But most of all, I hope that this legislature will act in this next session. It's well overdue. I don't mean to be critical of anyone, but it is time. It is time that we address this issue. And thank you for giving me a few minutes of your time.
Thank you, Director. And I guess on that positive note, Chief Justice, the Chief Justice, Vicky's before us representing AOC because her position was created by the Chief Justice or moved in there to address youth courts, or at least the children in that. It was not being done. I appreciate Chief Justice Randolph doing that. I think that, to your point, Director and Commissioner, that is a step in trying for us to get to these points that we're talking about. So thank y'all for your, honestly, for your honesty. And sometimes us legislators need to be slapped upside the head and told what we need to be doing and what we need to be hearing. And I appreciate that. And probably a lot of times, actually, we need to be slapped upside the head. But thank you very much. I think honestly, for the committee, this is a good kickoff to the session, if you will. We have worked for 2 years on these things, and it's time as a state that we address these. We're making progress in other places, but we need progress here. So I really do appreciate the judges being here, taking your time, because everybody that's in this room and that's in this system is doing it for the children. I truly believe that. And I know it's true. And we as a state need to keep that in mind. So thank you very much. And for that, we'll be adjourned. Thank you.
Oh.